This is a real courtroom, and this is a real jury pool.
We are trying to find out biases.
If you've ever gotten a jury summons in the mail, you just might recognize this. 11 million individuals report for jury service every year in America, with some never having seen the inside of a courtroom before.
Let me give you the lawyer perspective on jury selection, because I talk about it a lot from the jury point of view, because that's who you guys are. But let me give it to you from my perspective. While y'all are down in the first floor watching a video or hearing from a court staff member and they're telling you jury selection is really important, it's the hallmark and foundation to our civil justice system, we need jurors who are gonna be open, here's how it's gonna work. While they're explaining that to you, we get a sheet of who you are. I have very, very basic information about you. What is your name? What do you do? What does your spouse do? What city you live in? Have you ever been on a jury before? That's basically all I know about you. We get that list. The truth is we get it usually while you're walking into the courtroom, and sometimes we get it after you're already in there. You come in the courtroom and we are now on stage. As I get that sheet, I take out a big piece of paper, or I just use a manila folder and open it up. Really fancy. I am drawing a box for each person in whatever order you're gonna be sitting in, and I'm drawing that out. I am then trying to memorize your name. It's one of the skills, I don't know, weird skills that I have. You know, some people can like burp the alphabet. I'm good with names because I want to have a conversation with the jurors. It's genuine. Like, I feel like you should be respected and you should be called by, you know, Mr. Smith as opposed to juror 17, but it also helps to build a connection. The other members of my team, they may say this person is a nurse. Okay, that's my nurse. All right, this person is a teacher. Oh, that's my teacher. So we kind of divide it up. I'm focused on the presentation and asking the questions. The other members of my team are focused on getting as much information as we possibly can. Now, I like paper. Paper is my preferred method. It's a choice. We are a paperless office, except when it comes to jury selection. I don't know why. That's my like old relic. So when you first walk in, you'll see me, my client, and another lawyer from my firm. And I say, hi, my name's Mike Rafey.
Half my family says Raffy, the other half says Rafey.
I'm sorry you have to be here. This stinks. It's Monday morning. But my goal at the end of this is that you think it doesn't stink. You think that this was a meaningful opportunity that you had because my client over here has been waiting 3 years for their day in court. And this is the most exciting day of their year. This is their day. I want to get you through this as quickly as possible, but I want you to know how important this is. I usually tell the jurors that it's unfair that I'm asking them questions.
But I know this is to some degree unfair because I'm a stranger and I'm gonna ask you questions.
I say I'm gonna ask you questions because I need to get to know your opinions, your beliefs, and your biases. Bias is the word that lawyers and judges and the law uses.
We are trying to find out biases. All biases mean in this context are your personal experiences and how they may affect this case.
We all have biases. I am biased that I think Coca-Cola is the best. I live in Atlanta. Of course I'm biased to that. At the same time, though, I'm biased to think that the New York Jets might one day win a Super Bowl. Probably not gonna happen, but based on where I grew up, that's what I think. So we all have these biases. It's unfair for a stranger like me to come into a room at 9:30 in the morning and say, let me ask you some personal questions about your biases. But the reason I'm doing that is because client so-and-so over here needs to know this information and we need to know it on his behalf so we can make a good decision about whether you're the right fit for this jury. Now, we don't pick our jurors. We choose the jurors that aren't a good fit and we excuse them. When I'm thinking about jury selection, what questions I'm going to ask, I make a list of all of the bad things in my case. Or let's imagine I have a case that's a truck crash. You were driving down the road and you were hit by an 18-wheeler. Your rear ended at night. And the worst thing for you is that your right brake light was out that night. At least that's what the defense says is the issue. We say, no, it was hit by the truck and that's why it wasn't working, but that is one of the biggest issues in the case. I say, ladies and gentlemen, there's a really important issue in this case about a brake light. There's a rear end crash. The defense says that the tail light was out. We say it wasn't. You're gonna have to figure that out. How are you going to figure that out? That's my question, how? And they look at you like you're crazy. So you have to be prepared to give them some answers. Would you want to see maintenance records of the vehicle? Oh yeah, okay, somebody raised their hand. And then I say to juror number 7, who was nice enough to raise his hand, sir, why do you think that's important? And he says,
oh, you know, because maybe the car just been in maintenance. They knew it wasn't fixed.
Said those are really good points. Appreciate you sharing that. Does anyone else have another idea?
Oh, I'd want to see pictures after the crash.
That's a very good idea. Why would you want to see the pictures of the crash?
Well, you know, maybe it shows the brake light on. Maybe it shows it was off.
Anyone else have any ideas? How about talking to witnesses? Anybody want to talk? Oh yeah. But that's how I'm starting with my absolute worst fact. I want to do that for 2 reasons. One, in terms of time, that's my most important thing. So I want to ask about it because some judges limit how much time you have. So I don't want to put that as my 4th topic. We all get bogged down on topic number 2 and I've got to rush through 3 or not go to 3 at all. If it's the most important thing, I'm leading with it. Now you're probably thinking to yourself, why would you lead with such a bad thing? Because it lowers expectations.
How low can you go? Can you go down low?
during opening statement, for example, I tell the jury in every case, these are the best lawyers, I'm pointing at the defense lawyers, these are the best lawyers money can buy. I look up to those defense lawyers. They're phenomenal. They're great. I said that in my last trial, and it wasn't totally untrue. I respected the other lawyers. They are much older than me. I looked up to them. What it does is it builds up the expectations on their side. So then when push comes to shove and the defense has to show their cards, show their evidence, the jury's really let down when the only evidence they have is the testimony of the truck driver who rear-ended my client, who says, oh yeah, I think the brake light was off. But we have a picture of it lit up. And we have the police officer who says, yeah, I saw it on. And I have just destroyed the high expectations that the jurors have that I kind of gave them for the defense. And that starts in jury selection. So does conditioning the jurors or introducing the jurors to the idea that you're going to ask for a significant amount of money. The worst reaction you can get as a lawyer during closing argument is when you say to the jury, I'd like you to award X dollars, and they go, and they look at each other like, do you believe this fucking guy? So how do you try to prevent that? Well, you have to make the jury comfortable with the number you're going to ask. I don't tell the jury in jury selection, because it would be inappropriate, exactly how much money we're going to award. If I know I'm going to ask for $5 million, I'm going to say to the jury, if the evidence supported it, would any of you not be able to award $5 million?
Does anyone think that pain and suffering verdicts are sometimes too high, the ones I hear about in the news?
And you'll have jurors who will raise their hand and say, look, I'm sorry, but there's no way in hell I'm ever awarding anyone $5 million. And then you're able to identify those are people that, in terms of damages, probably can't be on the jury, because you're going to challenge them with the judge and say, Judge, even if the evidence supported it, they can't follow the law and award that money. A lot of lawyers are afraid to say things that aren't helpful in their case during jury selection, or at least topics that are difficult for them to overcome.
Does anyone here think that the burden in a civil case should be that higher burden? The plaintiff should have to prove beyond a reasonable doubt that he was hurt.
With the strategy that I use, where I'm asking the jury, what do you think? What would you want to know? What would you want to see? It's a mini focus group. My goal is that if I say to the jurors, what evidence would you want to know? And they say, I want to know these 7 things. Well, then I know what 7 things I need to present to the jury. But the rub is, with lawyers, we might not have all 7 things. Somebody might say, I wish there was pictures right after the crash, before the cars had been moved. And you have to listen to that in jury selection and say, that's a really good idea. I appreciate you sharing that. And you have to know you don't have that. And you have to be okay with that. And you have to plan for that. So I know during the testimony of the police officer, I have to say, hey officer, I know that most people take photos after a crash. Did anybody at this scene take photos of the crash that you know of? And he'll go, no. I'll say to the defendant, did you take any photos? No. Say to my client, did you take any photos? No. And then in closing argument, if that juror's on there, the one who said they want to see photos, I'm going to look right at that person and I'm going to say, I know some of us really wish there were photos because they wanted to see them after the crash. But if you remember what the officer, the defendant, and my client said, there are no photos. If they existed, you would have them. And then you turn to the next person and go through their evidence. So it's a mini focus group, but a lot of lawyers get worried about, well, they're going to say they want to see photos. Yeah, of course they are. But even if they don't say it, they're going to think it. So you need to know what they're thinking so that way you can address it. All right, so you get done with all your questions of the jury. Then it's the defense's turn. So they stand up. They usually give some sort of opening like, I'm not going to keep you as long as the plaintiff's lawyer did. So my questions are going to be really short. I'm going to get right to the point. Yeah, that's because I was the first one to go. If you went first, you would have taken all that time.
All right, good morning. And I promise I'm going to be shorter.
It's a little lawyer jab. Their questions typically jump around more. So they'll say, hey, juror number 9, you said this. I want to follow up with that specific thing. So after the defense gets done, the jury's typically excused out of the courtroom.
Everybody step out.
The lawyers then have a conversation with the judge about any jurors that aren't a right fit.
Are there any strikes or calls?
We say to the judge, jurors 1, 9, 13, 41, we think should be struck for cause. They have reasons they shouldn't be on the jury, and those reasons shouldn't count against us. They're not fair and impartial jurors.
I'm comfortable with striking for cause.
What judges are worried about during this process is reversible error.
Reverse, reverse. Cha-cha now, y'all.
And what reversible error would be in this situation is that the jury isn't fair. So the judge allows an unfair juror, someone who is not unbiased, allows them on the jury. If that happens, then the judge can later be overturned and there'd have to be a whole new trial. Is it a mistake if the judge says, hey, you know what, you can't be on the jury because you're not right for this case, but they actually are, they're totally fine? That is a mistake, but it's not reversible error, because when you exclude a fair juror, you're still still left with a fair jury. It's only reversible error if you have an unfair juror on the jury. And that's what the lawyers are playing to. We're saying, Judge, you got to get rid of juror number 9. They're fair and impartial. And the judge says, I don't know, it's right on the line. You say, Judge, it's not an error to kick them off. You don't want to leave them on because if they're not, we might be back here in a year
Take it back now, y'all.
doing this trial again. The judge goes, all right, I hear you. That's what you're kind of pitching to. The lawyers typically are excused for something like 5 to 15 minutes. And we go back in a room, hopefully, depending on the courthouse. Sometimes we find a corner and we just sit there and we all talk about the jurors. So when I'm doing jury selection, I'm ultimately responsible for picking the jurors that we're going to strike, and we get 6 strikes. So when I'm arguing to the judge about which jurors should be excluded from the jury, I'm expecting my team to get together and try to make a cohesive plan about what they think. Now, I'm not expecting them all to agree, but I want them all to come up with their lists, who they like, who they don't, more importantly, who they don't like, and talk about it with each other. You know, the reason we try to sit different people in different places is because Alexis sitting in the corner may see juror number 9 smirk, roll his eyes when you bring up pain and suffering. May see juror number 42 texting the whole time and not caring. And a juror who doesn't care, fine with me. They're not gonna skew one way or another. They're just there, so I don't have to worry about them.
Everybody asks me the secret of getting off of jury duty. The secret is that the people who don't answer jury selection questions end up magically finding their way to the jury.
So once we get our list of who we don't like, then we have to order it. The reason that we have to decide on an order is because the way the strikes work is it goes plaintiff, defendant, plaintiff, defendant, plaintiff, defendant for 6 times. So we want to put people that the defense may strike too, because they might want to strike one of the same jurors. We want to put that way on the bottom of our order, so that way hopefully they strike them and then we essentially get another challenge. After we've decided on our plan, we then go back in the courtroom, jury files back in, and jury just sits there. It's kind of an awkward process. I've never understood why this happens in front of the jury. The clerk will bring over a piece of paper with a list of all the jurors, and if our first strike is gonna be number 9, I flip to number 9, and I write plaintiff's 1, plaintiff's first strike. Then I hand it back, and then they walk it over to the defense, and they go, plaintiff's 9, plaintiff's 9, plaintiff's 9. They write down, plaintiff struck number 9. And then they put D6. And then it comes back to me and I go, D6. And then I look and I say, remember we were gonna strike 6? I'm glad we put 6 last on our list because they just struck 6. Great. Who's our 7th worst juror? Who's after 6? So you go back and forth for 6 times and then the judge looks at it. The judge says to you, I'm gonna call your number. If your number is called, you're gonna go get in the jury box. 1, 2, 3, 4, 5, 7. 6 got skipped. When a juror gets passed over, you see them go. And then you see the walk of sadness over to the jury box. Typically, jury selection takes 2 to 3 hours. I've had jury selection that has taken more than 1 day though. In federal court, I've had jury selection that's taken 40 minutes total because that's all you're allowed. Different states have different rules. Different courts have different rules. For the most part, as long as the judge feels that you are asking questions that seem to be meaningful and purposeful, judges are going to give you leeway to continue. So after the 12, 13 jurors are impaneled, are put in the jury box and now become the jury, you are given some very basic instructions. Don't talk to anyone about the case, including each other. Don't deliberate before you're supposed to deliberate. Do not do that. The judge will typically say the lawyers probably aren't going to speak to you outside of this room. Don't feel awkward if you get into an elevator. You say hi because you're a nice person and the lawyers just go and look down. That's normal. Usually in terms of timing, either you're going to be excused for a break or the judge is going to say, okay, are we ready with opening statements? And then you start. Meanwhile, all the other jurors have gone home, or sometimes, depending on how fast that jury selection went, a judge may conclude that you didn't do 1 day of service. That's the requirement, 1 day of service, until you go back down to wherever the meeting place was at the beginning, and they may put you in another courtroom. That's jury selection.
I'm out of here, y'all. Peace.
I did not plan on doing this video. I just started talking about it.